Hey guys, welcome to my legal classes. This is Ganesh Pujari and we were discussing chapter 16 of Indian Penal Code, which is all about offenses against human body. In that, we were precisely concentrating on hurt and grievous hurt in my last two sessions. In one session, I have explained the 20 sections, that is hurt and grievous hurt, how exactly they are structured starting from section 319 to 338. In my last session, I explained the meaning of hurt and grievous hurt along with 5 important case laws, and I have also discussed few other connected sections. Here, I am going to discuss all the sections related to punishment. Now, this is the last session as far as hurt and grievous hurt is concerned, and the first two slides are repetition from my last presentation, so I am not spending any time there. I will spend maybe 20 or 30 seconds and then I will go to all the other punishment provisions which we have not yet discussed. With that, I am taking you to the first slide. As I already said, this is the repetition slide where we have already discussed section 309 which defines what is hurt, section 321 which defines what is voluntarily causing hurt, and then section 323 discusses about punishment for voluntarily causing hurt. What is the punishment? It is 1 year imprisonment or fine or both, and these are non-cognizable offences, bailable offences. Any magistrate can conduct the trial and they are compoundable offences. Here they are compoundable with the consent of the person to whom the hurt is caused. This is also a repeated slide where we have already discussed section 320 which defines what is grievous hurt with 8 different points, and then section 322 discusses about what is voluntarily causing grievous hurt. Then section 325 discusses about punishment for voluntarily causing grievous hurt. The punishment can go up to 7 years imprisonment and fine, and they are cognizable offences, bailable offences. Any magistrate can conduct the trial for these offences, and they are compoundable offences if the person to whom hurt is caused along with the permission of the court. Section 324 discusses about voluntarily causing hurt by dangerous weapons or means. Now, what are dangerous weapons or means? It can be instrument for shooting, stabbing or cutting, or the weapons which can cause death, or any heated substances, or any poison or corrosive substances, or any explosive substances, or any such substances which are not good to inhale or swallow or receive into blood, or by using animal. If somebody is voluntarily causing hurt, then it is a punishable offense. Here the punishment can go up to 3 years or fine or both, and they are cognizable offences, non-bailable offences. Any magistrate can conduct the trial and they are non-compoundable offences. And remember, there is one exception for section 324, that is section 334. That is, if voluntarily causing hurt on provocation, then this section will not apply. We have already discussed section 325 in my previous slide, which discusses about punishment for voluntarily causing grievous hurt. Now let us discuss section 326. Now if you see, there is a straight relationship between section 324 and 326. The contents are same except for section 324 discusses about hurt, whereas section 326 discusses about grievous hurt. Now just because it is ending in grievous hurt under section 326, the punishment is also increases. It can go up to imprisonment for life or up to 10 years along with fine. And they are cognizable offences, non-bailable offences, and magistrate of first class can conduct the trial, and they are non-compoundable offences. Here there is an exception under section 335 where the voluntarily causing grievous hurt on provocation is an exception for this particular section. Then comes two important amendment sections, that is section 326A and 326B. Now both of them are referring acid, and when they are referring acid, it may be acid or all those items which have the substances of acid or anything that is of corrosive character. If any voluntarily causing grievous hurt by use of acid etc. under section 326A, the punishment is minimum of 10 years imprisonment, and it can go up to life imprisonment along with the fine which needs to be paid to the victim. And here the offences are cognizable offences, non-bailable offences, and court of session conducts the trial, and they are non-compoundable offences. Section 326B discusses about voluntarily throwing or attempting to throw acid, etc. In that case, the imprisonment will be minimum of 5 years, which can go up to 7 years along with fine, and they are cognizable offences, non-bailable offences. Court of session conducts the trial and they are non-compoundable offences. Section 327 discusses about voluntarily causing hurt to extort property or to constrain to an illegal act. Now there are two important parts, and let's discuss the first part, which is voluntarily causing hurt to extort property. For that, I will take an illustration. Imagine there is one Mr. A who got 10 acres of land. X comes to A and says, transfer that property to me. And A says, nothing, I am not going to sign the papers. Now X gets angry and he hurts A so that he can make A to sign the documents. Even after that, A is not agreeing. Now what does X do? He hits the son of A, that is B. Now B got hurt. Now A is worried. He is signing the paper. Now what happened? By hurting, X is extorting the property. That is one way of seeing section 327. On the other hand, the second part, that is voluntarily causing hurt to constrain to an illegal act. Now what happens? There is A and B. A is the father and B is the son. Now X is hurting B and says to A that go and put a bomb in the school. Now A doesn't want to do that because it is an illegal act, but he is worried that X might hurt him further. That means X might hurt his son further. So he is constrained to do that illegal act, and that is also covered under this particular section. So both the ways, if there is any hurt caused to extort property or to constrain to an illegal act, then the punishment can go up to 10 years along with fine. And the offences here are cognizable offences, non-bailable offences. Magistrate of first class can conduct the trial and they are non-compoundable offences. Section 329 is the aggravated form of section 327. There we are discussing about causing hurt. Here it is causing grievous hurt. And the punishment here can go up to imprisonment for life or 10 years along with fine. The offences here are cognizable offences, non-bailable offences. Court of session will conduct the trial and they are non-compoundable offences. Section 328 discusses about causing hurt by use of poison, etc. Now, if you are committing any hurt with usage of poison or drugs, etc., then that is a punishable offense. Now, you can conduct or commit such an offense in three different ways. One, you can commit by yourself. That means if you want to kill Y, you can directly give poison to Y. Or you can use others to commit this offense. For example, to give poison to Y, you may ask Mr. X to go and give the poison. That is also possible. Or if you are becoming part of such an offense, for example, X wants to give poison to Y and he asks you, hey Mr. A, please go and give poison to Mr. Y. Now if you are going and giving poison to Y on behalf of X, in all these three circumstances you are committing a punishable offense, and here the punishment can go up to 10 years imprisonment along with fine. And these are cognizable offences, non-bailable offences. Magistrate of first class can conduct the trial and they are non-compoundable offences. Section 330 is about voluntarily causing hurt to extort confession or to compel restoration of property. Here again there are two matters. One, if anybody is voluntarily causing hurt to extort confession, that means to take some information may be related to detection of an offense or misconduct, or if they are compelling restoration of property to satisfy any claim or demand, in that case it is a punishable offense, and here the punishment can go up to 7 years along with fine. These offences are cognizable offences, bailable offences. Magistrate of first class can conduct the trial and they are non-compoundable offences. Section 331 is the aggravated form of section 330, where the punishment goes up to imprisonment for life or 10 years along with fine, and there the offences are cognizable offences, non-bailable offences. Court of session conducts the trial and they are non-compoundable offences. Section 332 is very easy. It is discussing about voluntarily causing hurt to deter public servant from his duty. While a public servant is delivering his duty, if someone trying to deter, that means to prevent or stopping him from doing that duty, and in the process if they are causing hurt, in that case it is a punishable offenses, and the punishment here can go up to 3 years of imprisonment or fine or both, and the offenses here are cognizable offenses, non-bailable offenses. Magistrate of first class can conduct the trial and they are non-compoundable offenses. And the aggravated form of section 332 is section 333, which discusses about causing grievous hurt in the process, and there the punishment can go up to imprisonment for life or 10 years along with fine, and there the offenses are cognizable offenses, non-bailable offenses. Court of session can conduct the trial and they are non-compoundable offenses. Section 334 discusses about voluntarily causing hurt on provocation. If anyone voluntarily causes hurt to anyone because of grave and sudden provocation with no intention or nor knowing himself, in that case it is considered under section 334, because here mens rea is missing, and that is why the punishment is also very less, which is maximum of 1 month imprisonment or fine up to rupees 500 or both. While explaining section 324, I told that under section 324, section 334 is an exception. That means if anybody is causing hurt with grave and sudden provocation by using dangerous weapons or means, even then the same will be seen under section 334 only, and the punishment will not go higher than this, because it is considered as there was no intention to commit such an offense. Just because of the heat of the moment the same has happened, that is why the punishment remains less. Now section 335 is the continued form of section 334 or the aggravated form of the section 334. Here the grievous hurt is caused because of provocation, and the punishment here can go up to 4 years of imprisonment or fine of rupees 2000 rupees or both, and the offenses here are cognizable offenses, bailable offenses. Magistrate of first class will conduct the trial and they are compoundable offenses with the consent of the person to whom the hurt is caused. And under section 325 there is exception available, just like section 334 got under section 324. The last 3 sections are very easy. Section 336 discusses about act endangering life or personal safety of others. If anybody is acting rashly or negligently which can endanger human life or the personal safety of others, in that case it is a punishable offense, and here the punishment can go up to maximum of 3 months imprisonment or fine of rupees 250 or both, and the offenses here are cognizable offenses, bailable offenses. Any magistrate can conduct the trial and they are non-compoundable offenses. Section 337 is the aggravated form of section 336. There we are discussing only the acts. Here such act has caused hurt to someone. In that case what happens? The punishment can go up to 6 months of imprisonment or fine of rupees 500 or both, and they are cognizable offenses and bailable offenses. Any magistrate can conduct the trial and they are compoundable offenses with the consent of the person to whom hurt is caused and with the permission of the court. Section 338 is the further aggravated form of the same, where grievous hurt is caused because of rash or negligent act of a person. In that case the imprisonment can go up to 2 years or the fine of rupees 1000 or maybe both. Here the offenses are cognizable offenses, bailable offenses. Any magistrate can conduct the trial and they are compoundable offenses with the consent of the person to whom hurt is caused and with the permission of the court. That's the end of hurt and grievous hurt. If something ends, that means something new is going to start. I will pick a new subject from my next class. Till then, thank you so much for subscribing my channel. Please like, share and comment my videos. All the very best for whatsoever purpose you are watching my channel, and thanks again.